Cock-a-doodle-doo. Let's see what we got here. Let's see what we have here. View your channel. Am I live? Is it live? Is it real? Check it out. Oh, yeah. All right. So, the first thing, why is chat unavailable? Why is chat unavailable? Why is chat unavailable? Settings. Stream. Why is chat unavailable? Got it. Refresh. There we go. There we go. Now we're cooking with proverbial butter. Good evening, good morning, good afternoon, depending on what time frame you're in. Obviously, it's late morning where I'm at because the roosters are crowing still, as if right on cue. Yes, I am a real tech boomer. So I figure we start off today with a Turtle Boy analysis. I've not read the oh poop, this is just the denial of it. It was just stamped denied. Okay, so I did watch the I listened to the hearing on the emergency motion for protective order. And one of the things that I found was kind of funny was that previously Turtle Boy was asking me if I was smarter, better, more knowledgeable about Massachusetts law than his attorney. And obviously I'm not. But the big deal is jurisdiction. Jurisdiction is a huge deal. Now, I come from California, and in California, we unified all of our trial courts. All of our trial courts are now in the Superior Court of the state of California. There used to be, apparently, municipal courts and other things like that, but now it's all Superior Court. Every case goes in front of a Superior Court judge or a commissioner in the Superior Court. They're all Superior Court. Massachusetts isn't like that. They have at least a district court, which is a lower court, a court that handles misdemeanors and I believe some felonies. And then they have the Superior Court, which apparently handles all the big felonies, the big boy felonies, and will also apparently review district court decisions, or at least some district court decisions, or maybe offer a redo, a de novo. As we saw last time, Turtle Boy had filed a petition to have a Superior Court revisit bail conditions that were applied by a district court. So the issue here is, you can see up at the top of the page, this motion was filed in a district court. And the big problem is that the pertinent case, the Preventive Medicine Associates versus Commonwealth, stated that see right down in here, even in this quote, before any search of these emails may take place, the Commonwealth must present to a Superior Court judge and obtain to the judge's approval the search protocol to be used, and specifically the procedures proposed to protect against searches of privileged communications between the defendant and his attorneys. Now, the district court noted that the district court probably did not have jurisdiction to make a determination of whether or not the how to proceed on the taint team, because that is something that has to be applied to the Superior Court judge. Additionally, the district court noted that it would be incumbent upon the prosecution to bring the motion, because the Commonwealth must present, not the defendant, but the Commonwealth must present. And the third thing that is interesting is that the district court considered, without ruling on whether or not preventive medicine even applied, because the fact pattern was different. Remember, in preventive medicine, the uh, the indictment for charge A happened months prior to the Commonwealth getting the search warrant on the Google email drives for indictment B. And the issue in preventive medicine was that there was going to be a lot of communications between the defendant and the attorney on indictment A because that defendant had been previously indicted. And the district court noted, like I believe I noted it, I at least considered it when I was reading through preventative medicine and some other cases surrounding preventative medicine. But I did consider whether or not that indictment applied to a situation where, well, yeah, I mean, you get the search warrant, you execute the search warrant and the arrest warrant, or you execute the search warrant after the indictment has been held or has been filed, but no arrest has been made, and the defendant isn't aware of it. You're much less likely to catch improper attorney-client communications. I still believe that that a superior court judge will allow some form of taint team to review and segregate all of the attorney-client communications in on the particular devices. I still don't believe that any of the inf- uh, confidential informant kind of communications or communications between family and friends, communications between uh, Turtle Boy and his doctor or whatever. I don't think those are going to get caught. So anyway, the district court denied the part that so it was performance theater again by Turtle Boy's attorney. Turtle Boy's attorney said all the things that Turtle Boy would want him to say. There was not good grounds. There was not solid grounds for the other things that Turtle Boy was asking for, i.e., the return of his equipment, etc. And the Turtle Boy's attorney made the argument that even though the district court may not have the jurisdiction to order the taint team, the district court would have the jurisdiction to require the return of, or to order the return of the devices. And the district court denied that, and with good reason. Number one, because things can happen. The prosecution made a good point that things can go missing if they do mirror the devices. There could be issues, errors, changes, etc. And so they want to retain the devices in their original form so that any subsequent forensic investigation of them will show that the information retrieved is valid and correct and forestall any potential appeal. And there is no real reason for it. The Turtle Boy did not offer a compelling argument, nor his attorney. I mean, I know Turtle Boy's fans think that it was a compelling argument that Turtle Boy is this award-winning journalist, yada yada, but he is. It's not because he is a journalist that his stuff was taken. It's because he allegedly committed a crime, because there is probable cause that he committed a crime, because several judges found independently that there's probable cause he committed a crime. Apparently, there has been an indictment returned. I have not received a copy of it because everybody who wants me to cover this is too fucking lazy to get me a copy of the indictment, and that's fine. I mean, if you don't want me to be able to accurately cover this stuff and give you better analysis, I mean, you don't have to give me an indictment. But if you want the better analysis, you should get me a copy of the indictment, because a lot of the things that are going on here I can't really tell you about without having the indictment. But an indictment, if indeed an indictment did issue from the grand jury, that means that a grand jury found there's probable cause. So you have a judge issuing the search warrant, that's probable cause. A judge issuing the arrest warrant, that's probable cause. A grand jury issuing a indictment, that's probable cause. The Superior Court judge finding that there was probable cause is probable cause. So we have lots and lots and lots of probable cause. There might have even been a probable cause hearing that I'm not aware of, but there has been a lot. The district attorney alluded to the indictment. Is it available or is it a secret? Indictments would be filed. That's the. I mean, if the arrest warrant was filed, I can only imagine that the indictment would be filed. So, um, so yeah, I mean, it's there is probable cause. So his journalism is separate and distinct from it. It again is akin to what the auditors do. They go into some place and they create a disturbance while they are recording, and then they claim that they are being arrested or trespassed or whatever because of the recording, ignoring the fact that they created a disturbance. Or to be as fair as possible, to ignore that a disturbance was created. How about that? So it's not the recording that's the issue. It's the disturbance that's the issue. It's not Turtle Boy's journalism that's the issue. It's his advocacy that is the issue. His advocacy allegedly overstepping the bounds of what is legal. So that's the issue on that. So it was denied. It was properly denied. The court also made a big deal about why is it an emergency. The court went over, this isn't an emergency. The indictment was filed 5 months ago or something like that. It was or 5 weeks ago. It was 5 weeks. Yeah, it was filed a long time ago. Where's your emergency? You already had been talking to the prosecution. The prosecution said they wouldn't proceed without a taint team. So where's your emergency? Hmm. So so yeah, it was a doomed motion. But again, I strongly suspect that there will be a taint team, and that taint team will probably encompass all of the attorney-client communications because there are allegedly other cases going on with Turtle Boy. So that's still my best guess. That's still my prognostication. But the next thing we have is a motion for a bill of particulars. Now, a bill of particulars is pretty easy to figure out. It just asks for like who, what, when, where, why, and how. So this is a Massachusetts case. This is Commonwealth versus Baker, 368 Mass 58. And the court gets discretion to grant a bill of particulars. It is not a shall situation. It's a may situation. And as you can see here, a more liberal exercise of that discretion. The court has the discretion whether or not to order a bill of particulars. The court can order a bill of particulars in one of two ways: either sua sponte, it can decide itself that it needs to have a more particularized statement from the prosecution, or it can grant a motion for a bill of particulars. So it has discretion either way. A more liberal exercise of that discretion seems to be indicated when considering a conventional request for particulars of the time, place, nature, and grounds of the crime charged when the felony is charged in an indictment framed in the limited language permitted by Section 79. So basically, all the indictment really has to say is that basically it could be almost a verbatim recitation of the statute. So usually it'll throw on this time at this place. Usually it'll throw that kind of stuff in there, but it really just has to say the elements in the statute. Yes, Chaos Warden. Chaos Warden asks if the emails between Turtle Boy and his lawyer contains Turtle Boy saying he broke the law. Would that be attorney-client privilege? Yes, it would, because you can tell your attorney that you broke the law, and then your attorney can still defend you, but it's protected by attorney-client privilege. It helps your attorney, believe it or not. It is helpful to your attorney to know if you're guilty of the crime that he's trying to defend you on, because then he can more accurately and more narrowly tailor your defense to encompass the actual facts. Because if you committed the crime, there's a good chance that they're going to be able to show evidence that you actually committed the crime. Whereas if you didn't commit the crime, you can gamble more on them not being able to actually show evidence. So if you're like if I know you committed the crime, I'm going to be looking at procedural issues. I'm going to be looking at like technical issues, like trying to quash various warrants and things like that. Or I'm just simply going to be attacking their evidence and trying to introduce reasonable doubt rather than trying to prove you innocent. And I understand that you don't prove someone innocent, but rather than risk you going up there and lying and getting caught out on something that or putting another witness up who might get caught out and shown to be a liar. Because once one side is shown to be a liar, that really does prejudice the jury and really make them believe, okay, this side's lying and this side's telling the truth. But anyway, I'm getting in the weeds on a hypothetical that probably isn't warranted. But yes, you should always tell your attorney whether or not you've done it. And yes, that is protected by the attorney-client privilege. So then again, it continues. It continues. These observations are not to be construed as an invitation to defendants to request or as a suggestion to judges that they order particulars which, in their requirement for detail or otherwise, amount to the imposition of a straitjacket on the prosecution. So a request for a bill of particulars is not intended to straitjacket the prosecution. And in fact, the prosecution can amend their bill of particulars to encompass new details. Well, hold on a second, Luddite Neanderthal. If a client tells you that they intend to do X, that would be protected by the attorney-client privilege because he is literally asking you for your legal advice at that point. There are a lot of things that are illegal or potentially illegal. And if your client does not have the freedom to come to you and say, I intend to do X, is that something that I can do legally? If that would immediately strip attorney-client privilege, then that would completely defeat the point of asking your attorney for advice. So your statement, as stated, Luddite Neanderthal, is inaccurate. So, no. So with that understanding in mind, so a bill of particulars is looking for the time, place, nature, and grounds of the crime charged, and it's not intended to be a straitjacket to the prosecution. Now comes Mr. Kearney, defendant herein, by and through undersigned counsel, and hereby moves under Massachusetts Rule of Criminal Procedure 13b1. Let's look at that, I guess. Have that one, right? Yep. Have that one. There is 13. B1, a motion within the time provided for filing of pretrial motions, basically up to 21 days after the trial is set, the date for the trial is set. That's incorrect, Luddite and Neanderthal. That's absolutely incorrect. That's absolutely incorrect. In fact, unless there is immediate harm, there is imminent harm to somebody, like physical harm to somebody, I don't believe. Let's look it up. I believe I am required by the rules of attorney-client confidentiality to not disclose it. I think a lawyer may, but is not required to, reveal information protected by this one to the extent that a lawyer reasonably believes the disclosure is necessary to prevent a criminal act that a lawyer reasonably believes is likely to result in the death of or substantially bodily harm to an individual, except as provided in paragraph C. So I am required to keep that information confidential. And show me something, Luddite Neanderthal, that says that my client loses attorney-client privilege if he tells me something like that. Now, there is a difference between the rule about client confidentiality, attorney-client confidentiality, and the rule of evidence about attorney-client privilege. But let's go to the evidence code, shall we? Let's go to the evidence code and privileges. Lawyer-client privilege. I don't see anything in here where it says that that it is waived if the client talks to you about committing a crime. So there is no privilege under this article if the services of the lawyer were sought or obtained to enable or aid someone to commit or plan a crime. But if they're just telling you that they're committing a crime, that's not seeking advice to aid them in the commission of a crime. No privilege under this article if the lawyer reasonably believes the disclosure of any confidential communication relating to the representation of the client is necessary to prevent a criminal act the lawyer reasonably believes is going to result in the death of or substantial bodily harm to an individual. Well, there you go. So again, the same with the confidentiality rule against confidentiality. The lawyer can break it to disclose it if there's going to be death or substantially bodily harm. So you're going to rob a bank tomorrow is completely not true. Yeah. All right. So once again, chat is wrong. John is right. I love it. I love it when people come into my comment section trying to be pretend lawyers, like the pretend lawyer the last time who said, what was he talking about? That's prior restraint on something that fucking wasn't prior restraint. Jesus Christ. I've been practicing law for 26 years. I know what prior restraint is. Oh, you fucking don't, and you're dumb. Oh, good on you. See, this is the correcting. If you've been corrected, like if you were wrong, you just say, hey, yep, I was wrong. Easy peasy lemon squeezy. Good job, Luddite Neanderthal. All righty. So back to so it's not, the attorney isn't bound by attorney-client confidentiality. If you come and tell them about, like, I'm gonna go murder my ex. Like if you go to your attorney and you say, I'm gonna go murder my ex, then the attorney is no longer bound by attorney-client confidentiality. And he may, if he thinks that it can prevent the crime from being committed, if he can prevent the bodily harm, he may at that point tell someone, which obviously would break attorney-client privilege because he could tell. Now, if your client comes to you and says, hey, I'm thinking about murdering my ex, or I'm going to go murder my ex. Let's say if he says, I'm going to go murder my ex, and then you wait and he goes and murders his ex, well, then all of a sudden you can't prevent it. And so attorney-client privilege is back. Oh, Israel doesn't think I corrected him. Well, you know what, Israel? I'm going to defer to your superior legal chops. I love people. And 13 Kings is back. The Turtle Boy supporter who's going to support him come hell or high water. All right, so back to the motion. I'm sorry. Now comes Turtle Boy, defendant herein, blah blah blah. He moves through 13b1 of the Massachusetts Rules of Criminal Procedure that the court order the Commonwealth to provide a bill of particulars concerning the cases, or charges in the cases. And he states as follows: the charges rely on vague, conclusory descriptions of incidents where the discretion or discovery provided sheds little light on the defendant's behavior. Now, I don't know what discovery has been provided. After arraignment, usually there is an order by the court for the defense to provide for the prosecution to provide the defense with all of the incriminating and exculpatory evidence that the prosecution has. So that may have happened. I don't know. But if it has been, I would be surprised because everybody seems to be very, very sure as to whether or not Turtle Boy did or didn't do the alleged acts. So, number 2, the charges concerned First Amendment protected journalistic activity never before charged in the Commonwealth. Again, this is playing up to Turtle Boy's fans. Therefore, it is impossible to address the allegations without specific binding disclosures from the Commonwealth as to the manner of the incidents alleged. Now, remember that these observations are not construed as an invitation to defendants to request particulars which, in their requirement for detail or otherwise, amount to the imposition of a straitjacket on the prosecution. So, it is unlikely that the court will order specific binding disclosures. Again, remember, the Commonwealth can amend their bill of particulars with approval of the court. As a matter of substantive and procedural due process, interesting. As a matter of substantive due process, what substantive due process are we missing here? Procedural due process would require notice of what specific charges and an opportunity to be heard. But what substantive due process is missing? I don't know. Turtle Boy must know what heretofore legal and unprosecuted journalist activity is now perceived as criminal by the instant police and prosecutors. That's garbage. All of that is garbage right there. Statement number 2 is pure shit. Now, whether or not you think he's an award-winning journalist is immaterial. Number 2 was shit. He wasn't being charged for journalistic behavior, and you could tell that he's not being charged for journalistic behavior because in his declaration and in previous pleadings on his petition about the bail for the Superior Court to revisit the bail conditions, in that one he alleged lots of things about him being an advocate, about him going out and protesting. He compared himself to Martin Luther King Jr., who was not a journalist, who was not doing journalism. He was doing advocacy. Fucking guinea fowl. So that's how you know it's shit. Like if he didn't like, and Turtle Boy knows it's shit because Turtle Boy raised the issue of him doing advocacy, of him doing expressive protesting, petitioning his government for redress of grievance, etc. So Turtle Boy knows it's not all about journalism. So this particular section, number 2, is pulled pure bullshit. The defense specifically requests Commonwealth be ordered to describe A. Jesus fucking Christ! Okay, I'm back. The defense specifically requests that the Commonwealth be ordered to describe A, what aspect of the enumerated incidents allegedly comprise witness intimidation accompanied by the requisite intent or recklessness as required for a violation of the statute. Well, again, I'm not entirely sure that they're entitled to that because, again, they're not required to straitjacket themselves. Such disclosure is necessary and compelled, Turtle Boy says, by the Due Process Clause of the United States Constitution. Which one? Which one? Which Due Process Clause? Would be really helpful to know. In Article 12 of the Massachusetts Declaration of Rights, which guarantees that no subject shall be held to answer for any crimes or offense until the same is fully and plainly, substantially, and formally described to him. Now, the Massachusetts Declaration of Rights, Article 12, says no subject shall be held to answer for any crimes or offense until the same is fully, plainly, substantially, and formally described to him. That has typically been determined to be the indictment. The indictment fills that role. The indictment typically fills that role. Hold on. I thought I had one up. They went over it. Really? You fuckers just came back? Jesus H. Christ. Well, I don't have it up, but generally speaking, that has been held to be sufficient just to have the indictment. Now, in some cases, it isn't. Specifically, cases like where there have been two acts alleged, but only one charged indictment returned, and that one charged indictment could apply to either act. So in that kind of instance, that's really where you're looking at something where you want a bill of particulars, because again, bill of particulars is there to tell you the time, place, nature, and grounds of the crime charged, right? So in one of the cases that I looked at, there was an issue where there was two acts which could have been and I forget which case. I have multiple cases up. Was it Reese? Was it Kelly? Was it Burns? I don't remember which case it was, and I may have deleted the case. But the issue is educating the defendant on the specific acts in order for the defendant to prepare his defense. So the time, place, nature, and grounds of the crime charge. That's really what you're looking for. So this is, generally speaking, has been held to be satisfied by the indictment, and it's only if the indictment is unclear that a bill of particulars is required. But the court has discretion to order one. Again, the court has discretion to order one if it feels that it would be helpful to the court and to the defendant or to the defendant to have a more particularized statement. Also, the defendant, if the defendant feels that it would be helpful to the defendant can ask for one. Where, in addition to Rule 13, the defendant's right to disclosure attains constitutional dimension in Article 12. The defense asks the Commonwealth be ordered, consistent with Article 12, to, quote, fully, end quote, quote, plainly, end quote, and, quote, substantially, end quote, describe the offense in writing to her. Learn something new about Turtle Boy. describe the offense in writing to her rather than provide one-sentence answers, as is common practice by the Commonwealth in answering such requests for bills of particulars. And then a thank you. So this seems like it's copied from something else, from some other pleading. This attorney may have a motion bank of some sort that he's pulling this from. The right to disclosure, I'm not sure of. I'm not sure what the defendant's right to disclosure is, because he can request disclosure. He has a Rule 13. The defendant may request, or the court may on its own motion, give an order the prosecution file a statement of particulars as may be necessary to give both defendant and court reasonable notice of the time of the crime charge, including time, place, manner, or means. Right? But this is discretionary. The court may order it. The court fucking amateur hour over here. May order. The court may order. You don't have a right to it. The court may order it. So there is no right to disclosure. I don't know what he says, what he means when he says it attains a constitutional dimension in Article 12. The Article 12 is your due process. That's due process. That is you have essentially the right to be indicted, and that indictment has to say the elements of the crime. And even if it doesn't state all the elements of it, a crime, it still may be sufficient to place the defense on notice so much enough so that the defendant can be indicted. Are you not smart enough to understand I'm on your side about this? Okay, hold on. I already did. It's always, I'm an attorney, and I don't think you are, so you're wrong. Well, I know you're not an attorney, Israel D, so I know you're not an attorney. And even if you are, you're not right about this. Show me wrong. Prove me wrong. You know, you can type in more than just I'm right and you're wrong in there. I showed you why. So that's it for Turtle Boy. I think he will be granted a bill of particulars, and I think that it will not straitjacket the Commonwealth. I don't think the Commonwealth is going to order that the Commonwealth do more than just provide a bill of particulars setting forth the time, place, manner, and means. Now what? Oh, bastards. All right. Next up, we're going to do triggered. It has to be in Israel D. There is a rule that if you type triggered, in order to win, triggered has to be in all caps. So the first person to type triggered in all caps wins the internet argument. So, let's see what we got here. What do we have here? I'm gonna take a break for a while. I might come back this afternoon, but I'm gonna take a break for a while. Let the guinea fowl get out of the backyard. Maybe they'll move to the front yard or whatever, and we'll go over. We're gonna go over Las Vegas Metropolitan Police Department, and we'll go over Springer versus the 7th Judicial District Court. But I don't want to fight with the guinea fowl right now. So thanks for watching. Have a great day, and I will be back probably tomorrow or this afternoon.